Order. Thank you, lady. All right, so could we please have a roll call, Jerry?
Yes. Commissioner Blaylock,
Here.
Commissioner Dat, arriving later, Commissioner Gratiter,
Here.
Commissioner Levin,
Here.
Commissioner Rothbart, absent, Chairperson Brightcloth.
Here.
We have a quorum.
Excellent, thank you. So let's talk about the minutes from March the 4th.
Before we do, Lori, if I could just, for our record, I should be doing this every time we do these meetings remotely. We're meeting remotely due to the ongoing disaster proclamation emergency orders issued by the governor of the state of Illinois, which suspend the normal rules for open meetings under the Open Meetings Act and allow us to meet like this remotely.
Thank you. Okay, let's turn to the March 4th minutes. Are there any comments on them?
As corrected with your corrections, Lori?
Yes, as corrected, if everybody is okay.
Yes.
Any further comments on the corrected minutes? I do not see any hands, so I will entertain a motion to approve.
I move we approve the minutes as approved.
And I will second.
All right, we need a roll call, I believe.
Mr. Blaylock,
Aye.
Ms. Gratiter,
Abstain.
Mr. Levin,
Aye.
Ms. Brightcloth.
Aye,
Motion passes.
thank you. Are there any visitors wishing to address the Plan Commission?
I think Daphne is able to see whether there are any emails that have come in.
I was not prepared for that, so just give me a minute to log in.
No problem.
How many people should be serving on the Plan Commission? Are we at our full number?
I think we're still, because we had one person who moved out of town, I think we may be down one. Normally there are 6 plus the chair.
6 plus the chair.
So Bruce, the password didn't save on my laptop and I'm looking for it. Do you want to come back to that?
Sure, we can check in later. Do you want, is the password on the, I guess it's, you don't need anything that's on the agenda. You're looking for the village.
Yeah,
Internal.
John had printed something out for me one time when I needed the password, but I'm not sure I have it. So I could text the chief and ask him for it.
Okay, okay. This is just on the, in the event that, someone who's not, obviously here with us on Zoom has a question or wants to call in. We can come back later.
Okay, thank you. I'll work on it
Okay.
right now.
All right, we'll do that. There is no old business. And turning to new business, we have a public hearing to consider a request under Article A, Chapter 11 of Title 9 of the zoning ordinance for the property commonly known as 2240 Riverwoods Road to reduce the required side yard from 30 feet to approximately 22 feet to allow construction of an addition for a new elevator to serve the existing residents.
Like, if you do.
Bruce, would you like to introduce us to this
Sure.
topic?
Sure. Everyone can hear me?
Yes.
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 first of all, let's welcome one of our residents. Sir, would you, could you introduce yourself? You're the applicant and want to just say hello to us, unmute yourself and.
Hi, can everybody hear me?
Sure.
Yes.
My name is Byung-Moo So. I am a resident and the owner of the 2240 Riverwood Road. Me and my wife used to live in Northbrook some 20 some years, and we passed by Riverwood, about almost 10 years, and all this time was we were marveled about the ambient and all the surroundings of Riverwood. So we decided to purchase a lot, and then we built our house and moved in 2.5 years ago. We are so-called quote super senior. I am 76 years old. My wife is 75. We were relatively good health, and we enjoy the environment and all that the forestry and surroundings. But so we built a house to accommodate our son's family, which lives in Bannockburn. They used to live in the Woodland, right across the golf course behind us. And so we built a house to accommodate our family, hoping that all the family stay together, which we have been doing except this pandemic period. So happened a year and a half ago, my wife had developed the osteoporosis, and I am relatively good health, but I'm genetically inherited asthmatic condition, and it became it started to show the symptom. Not so much me, but my wife's osteoporosis is quite precarious, because we built a house in a pretty minimalistic and contemporary style of the house. And when we built, we constructed all the environment impact rather. So we built the house almost carbon-free zone. We have solar panel, so we use net zero electricity because we got smart metering. And then we use the geothermal so that our energy consumption is almost minimal. And we have a well water. So we are pretty frugal about the city waters. Now, because of the structural concern, when doctor prescribed the medication and twice a year injection about the osteoporosis, the gentleman that's in this site, named by Tom Surik, he's the builder and the designer of the house. It's almost very difficult, if not impossible, because of all the geothermal piping structure and solar panel up in both above the garage and above the roof deck, which sold some total of 54 panels, and all the pipings and water pipings. And the structure of the house is we just couldn't find any internal structural remodeling to accommodate the lifting structure. So after consulting our physicians and this gentleman, Tom Surik, about the structural engineering, we decided to request a zoning variation to accommodate our aging bodies. that's where we are. In fact, just now, about an hour ago, we found a deer just to give a baby in our front yard because we were not allowed to cut the tall grass to maintain the prairie and ambience. So here we are. That's the reasoning that we are requesting a variation to accommodate the elevator installation, not for anything else, but for a we are trying to maintain our lifestyle and the well-beings and so that we can continue to enjoy the Riverwood and this house that we built.
Thank you for that. Laura, I was going to make more of an introduction, but this is probably a better of introduction. Maybe I can come back to the sort of the legal standards we're operating under. Maybe it would be more useful to now, if you had questions about the reasons for the request for the waiver, or ask the contractor about any of the details of the construction or the size of the elevator. You could ask those questions now, and then I can maybe wrap it up with a description of the applicable legal standards, if you want.
Oh, yes. Oh, yes. Are we ready for questions? Is the
Well,
contractor on?
Let me ask the commissioners, would you like to go through the standards and the law first, or would you like to ask questions first?
Either way.
Does anybody have a preference?
No, I think we could go ahead and ask the questions. I think Bruce could maybe summarize it at the end.
Okay, everybody read the memo, I hope, and so you have the gist of it. All right,
Yes.
let's go ahead. Let's go ahead with questions. Sherry, did you want to start?
I can. I have several.
Good.
I want to preface this with the fact that the gentleman who's applying for a variance is younger than we are. So I am a super senior and my husband is senior to me. As a matter of fact, he's moved downstairs because he can't make it upstairs anymore. And I think the idea of an elevator is super, but I have some concerns with it. Concern number one is the height of the tower.
Mr. So is the one who is residing in the house. It's not me.
Well, who's answering questions?
I'm the builder. I built the house for him. So I'll answer the questions structurally the best I can.
Okay, so first question is, why does it have to be so much higher than the roof of the house?
It's not higher than the roof of the house. It goes to the top of the parapet wall for the elevator override.
I thought I read somewhere that it was higher than that.
No, it
No?
matches the existing.
Okay. Second question, I see that this is a transparent elevator, which I think, by the way, looks very cool. I'm concerned about lighting. Is it lighted all the time? Is it lighted only when it's in use?
It's only lighted when it's in use. And because it is the type of elevator it is, it has to be inside a conditioned environment. So it can't be a typical commercial elevator that you see is that just a shaft. So that's the reason for the larger structure for the elevator to sit in, because you have to be able to access it from all sides. On the
Okay, what
inside
about noise?
No noise whatsoever.
No noise at all?
No.
Okay, so noise is not an issue. I guess my last question is a question for Bruce, not for you. And it has to do with precedent, because that's what concerns me here. So how about I turn you loose and let the other kind of commissioners have at you?
Why don't we take all the sort of the factual questions, and then we can come back to that. It's more of a legal question, and I'd be happy to, but
That's why I backed off, Bruce.
maybe I suggest we defer that. Okay.
Any other structural questions while we are talking to the builder?
Just a clarification to the contractor. The elevator, the picture of the elevator that shows it being transparent, that is in a housing on the outside of the house. Is that right?
Yeah, so our plan would be to construct the shaft as long as we can get the fire rating with the glass for the shaft. So that way the shaft is built almost entirely out of windows. So you'll see windows that construct the shaft and then the glass elevator inside.
Okay, thank you.
I have a question, which is, It seems like a very large structure, 10 by 10. What is, can it be smaller than that?
It can't be because the elevator itself has to have 2 foot of access all the way around because it has to be within the building envelope.
There is no alternative to that? That's the only kind of elevator that can be put in?
That's the elevator we researched for the house to go with the style and architectural design of the house.
10 by 10 seems very large to me, especially when it's in the side yard. But that's, you know, that's my comment. Others may disagree.
If
Other
I may jump,
questions?
if I may jump in, the 10 by 10, Tom, you can correct me. 10 by 10 is a outside housing. Actual elevator is inside the housing, which is 2 foot narrower.
There was a brief reference made in your introduction about, other locations in the house. I'm curious, there is no other way to use a different type of device, a different type of elevator or a way to lift or come down or anything. Can you give us a little bit of description about your efforts to find a suitable place?
Well, the second floor off the rear of the building, it has moment frame steel supporting the floor structure. Then there's 18-inch PSLs that backspan into the floor assembly. So we'd have to remove the entire rear canopies of the house in order to penetrate the floor on the sides of the house. And in the center, there's just no way to get it through the center column to have access. On the second floor, you won't be able to access the bedrooms. We looked to take out a laundry room and go into the master closet. We looked at all the different alternatives. We just couldn't find a way up.
So if I may, on top of that, our house is sitting in kind of a more or less square shape. West side is facing our next door neighbor, and east side that we're intent to requesting a permit is there's nobody there except the orphans of the storm and the wooded area. So we asked before we apply, we asked for the directors of the orphans of the storm if our intended structure would hinder any of their activity or even atmosphere. I think I will attach their statement, and they give us what I call 100% endorsement that they are okay with it.
Any other questions? Henry?
Well, if you're going to go on to a non-structural question, you want to finish that up first?
No, just anything that anybody has. We may have bounced back and forth.
One of the requirements, as I understand it, for a variance is to show that the disability is actually there and it requires this type of accommodation. So I had sort of 3 different questions, and I understand if you're reluctant to answer them because it would be releasing some medical information. You may be uncomfortable, but I'll ask it anyway. My understanding is that it's really your wife that you have major concern about with her osteoporosis. So my first question is, has she had any fractures due to the osteoporosis so far, bone fractures?
She has not had, fortunately, bone fractures. That's what I'm afraid of. In the age of the 75, God forbidden, if she slipped on the stairs, anything else, then I don't want to even think about it. Now she started the injection process attached to the doctor's prescription and the injection record. So it's more or less a preventive, Actually, and I am developing. I don't mind because it's not. I have a severe asthmatic condition and start the onset of the emphysema. But I am able to come up and down. You know, we have a 40 steps stairs and the wooden steps is pretty slippery. It's nobody's fault, but I just want to have easy solution would be we move up, but that's not what it is. So we built the house, we love the house, we have our grandchildren around, and we want to maintain our dream of the house and the lifestyle. And if it doesn't bother anybody else.
I'm also very senior to you, so I understand these life situations. My second question is, do you have a handicap license plate?
No, we did not, and no, we didn't. As I said, it's developed at about a year and a half. So we didn't. So far, we did not require, and we didn't ask for it.
And my third question is, so far, can you give us an example of where the osteoporosis limits one of your life activities?
She's having a difficult time walking up and down the stairs from first floor to a master bathroom, and it's a very uncomfortable feeling when you see your spouse takes, with the exaggeration, 3 minutes to come down the 10 stairs and holding the rail. So I'm trying to do what I can.
And so as I understand it, this is more preventative in the sense that you don't have anything at the moment, but you're doing this to help prevent an accident or a fall or her discomfort. Is that correct?
In a nutshell, yes.
Thank you.
And she has a discomfort. In fact, she has a back spasm now, past a month or so. But I think it is just comes all aging process and the imbalance of the body structure. If you put the force in on one side, I mean, everybody should know that, but the human body is very, very symmetrical structure. So if one goes away and the other body part has to compensate, and simply put it, I wish I make it a little bit easier for my wife and me. That's, yeah.
Thank you. I don't have any more questions.
Any other questions from anybody?
No.
All right. Bruce, would you like to give us the?
Yeah, let me take you through a little bit of what we have in our zoning code and why we're here tonight in this particular format. And thank you for your careful testimony. It was helpful. As you saw in the memo, there are two different ways of approaching this kind of request. One would be under the rules for granting a variation from requirements of the zoning code. And the test for a hardship has a number of criteria. Some of those criteria have to do with the characteristic of the property itself. The idea of a zoning variation is that, you know, we adopt zoning rules, we apply them to hundreds of properties. Not every property is the same. Properties are differently shaped. Some are on cul-de-sacs, some have unusual conditions, topographic conditions. And if you have one rule fits all, then occasionally there's something that becomes very burdensome to a particular property. And so the idea of the zoning variation is that you can make adjustments to your zoning code when applying the general rule isn't the fair thing to do with the particular property before you. When I looked at the application and I thought about the fact that this was a recently constructed home on a lot that's a fairly regular rectangular size lot and 150 feet wide at the point of the house, that's not, you know, an unbuildable lot. It's not irregularly shaped. There weren't any natural improvements this magnificent heritage tree or, water course or something that changed the way the house was laid out. And so if this were to come directly to the Zoning Board of Appeals, it could still potentially, but if it came directly to the Zoning Board of Appeals, I felt that the case for a hardship, as it's defined in our code, wasn't a really strong case. And when Sherry Graditor asked about precedent, I'll give a whole speech about precedent in a minute, but basically, we've given very few variations in the history of the village of Riverwoods. One of the reasons is that we have such large, generous lots. And when people start with 1 acre or 2 acre lots, it's not very often that they run out of room and need a relief in a side yard or something like that. We have granted a handful of variations, but unlike communities, Evanston or another community where they have a whole, recurring agenda, regular, every month there are variations being considered. In Riverwoods, literally, there's probably been 5 or 6 I can think of in 20 years. The ZBA doesn't meet that often, sorry to say, to our new incoming chair of the ZBA. So I'm explaining this because this is why I didn't recommend this path for the consideration of this request. I didn't think that there was anything about the property and the application of the zoning that made the zoning particularly burdensome. These typical standards under variations are considered don't look at the individual characteristics of the owner. They look at the characteristics of the property. On the other hand, we've been instructed by various federal laws, the Americans with Disabilities Act, the Fair Housing Act amendments, and so forth, that when people have disabilities that interfere with everyday activities, normal activities of daily life, and they seek to have some relief, accommodation, or waiver from the general rules that apply to them, that a governmental body has to make a reasonable and necessary accommodation if it can. And of course, these criteria have been developed to the nth degree, and there's all kinds of nuances about what is reasonable and what is necessary. And in our village, in our zoning code, we added a new section a few years ago, and this came about as we were considering a potential group home for senior citizens, to look at what are reasonable and necessary accommodations. And so I'm skipping past all of the standards in the staff memo that talked about hardship, and I'm just going to go to the standards that talked about necessary and reasonable accommodations. One of them is, and again, this comes from a line of cases, often cited cases, the U.S. Circuit Court of Appeals for the Seventh Circuit, our jurisdiction. A necessary accommodation is one that would provide a direct amelioration of the disability's effect for the housing in question. But for the application of the zoning provisional rule, the person or person with disabilities would have been able to access such housing. The Fair Housing Act amendments are particularly concerned with allowing people to access housing, to have the same housing opportunity as other people. And it becomes maybe a bit of an interpretation as to whether being able to remain in the housing is also accessing housing, but I wouldn't say that it's outside of what was contemplated. These standards are being reinterpreted and expanded and considered again and again through a number of applications. But what we're hearing tonight is that this accommodation would allow the resident to stay in the house and ameliorate the effect of the disability. So in that sense, I think you can look at that standard and evaluate whether what you're hearing tonight squares with that standard. That's as to the necessity of the accommodation. As to the reasonableness of it, the question is whether the requested relief, and you list here these 4 items, is efficacious and proportional to the cost to implement it, doesn't fundamentally alter the nature and purpose of the zoning code, is designed and located and proposed so that the public health, safety, morals, and welfare will be protected and won't cause substantial injury to the value of other property in the neighborhood. Again, this plan commission can look at those standards. I will say that I think this whole framework of evaluating a request for relief is relatively new for our village. It just came about recently as we considered a group home. We've made some recent amendments to the text of the zoning ordinance, as you all know, to be more responsive to those kinds of requests. And the court cases say that the determination of whether an accommodation is necessary and reasonable depends on the facts of the specific case and are highly fact intensive. That's the way courts talk about it, highly fact specific. And so when you ask, does this set a precedent? And I've had some discussions with other people. We have a lot of people aging in the village. We have a lot of people who want to stay in their homes. Does this mean that every time somebody is having trouble with the house, we should consider relaxing a rule if it would allow them to stay in the house? My answer would be worry about that problem when it comes about. I don't think that you worry about a problem when you have one case in front of you, unless you can look at it and say that granting this relief would fundamentally alter the nature and purpose of the zoning code. I think, Jack Siegel used to always say this when someone said, well, if we prove this, doesn't that set a precedent? No, you have to comply with the standards, satisfy the standards. Each and every applicant has to satisfy the standards. And when you determine as a board, if you do determine that the standards in a case are met, it's fact specific. It's dependent on the facts before you. And there's nothing that obligates you to come to the same conclusion when the facts are different. It's just, you'll have to be guided by that. So no one else is going to be able to describe exactly what it's like to have their mobility impacted by osteoporosis in exactly the same way as you heard tonight. And no one else is going to have the same 40 steps exactly as you've heard tonight. So there's no way to say every situation is basically the same. This is, this house, maybe they could have thought about putting in an elevator, 3 or 4 years ago, but they didn't. Now, because of the way the house is constructed, it's very difficult, apparently, to put it, somewhere else. Those facts won't necessarily be present in another situation. So there's nothing that constrains you when you look at these facts to say, well, I have to bend the rule against my better judgment in another case. I will say I did take a look at the some of the more recent verbiage that the U.S. Department of Justice has for helping us consider what constitutes a disability. And the language is still very clear in the standards that impaired mobility and difficulty with breathing are characteristics of a disability that interfere with everyday activities of life. So if you look at these criteria, I would tell you that this is a case where you could consider them, you could apply them, and you could grant the relief that's being requested, and you would be doing so, I think, in a manner that complies with law. And if you find that the standards are not met, I would not tell you that you made a mistake, because you're going to look at the evidence and decide for yourself. But I would just caution you that unlike a long line of cases in the zoning world that talk about the reasonableness of hardship, or what constitutes a hardship and that kind of idea, there aren't a lot of cases. There are some, however, but there aren't a lot of cases where this kind of accommodation under the Fair Housing Act amendments has been considered, that I could say I have a pretty good sense of where we are. The one case that I cited in the memo was with the Village of Wilmette some years ago. And In that particular case, you saw that in that case, as I explained to you, the applicant had osteoporosis and wanted a driveway that was front loaded. And the village had a very valid reason for saying, we don't want you to have a front loaded driveway here. We think it's dangerous. Even though you have a disability, perhaps we're not sure you do, but even though you may have one, we think it's dangerous because when you back out, you might injure pedestrians. The case went to trial and the village lost. And it went to appeal, and the appellate court said, why would we disturb what the trier of fact said? It's highly fact dependent. They heard the evidence and they considered it. So if I were offering legal guidance, I would say the intent of the federal law is to be somewhat liberal and expansive because you can be second guessed on whether or not you were right in rejecting a request for what's reasonable and necessary. So I would suggest that you have a pretty strong feeling about it because I think the intent of the federal law is to be somewhat responsive to these requests if they meet the criteria.
I will add that we are allowed to make conditions on if we do grant a waiver, that we can add conditions to it to make it very specific. So
right.
we can
Right. This would
in
be
mind.
the way. Again, the federal government doesn't give a lot of guidance as to how you actually implement a request for relief like this. In the zoning world, you adopt an ordinance and it's recorded with the property. I suggested when we drafted our provision a few years ago that this kind of relief be treated the same way so that it be specific, embodied in an ordinance that was very clear that it was this particular structure, this particular residence. It didn't, if this residence was taken down, it didn't, stay around for the next residence. It's very specific to the situation. And I would anticipate if you recommended approval that it would be the same sort of condition here. Any questions?
Well, no, but I will state that I have a problem with this, very frankly. I think this is an anticipatory request for a variance that right now is not necessary. Pleasant, yes, great to be able to go up and down in an elevator instead of anything else. But necessity, yes, his wife has osteoporosis, as do I, and as do a whole lot of aging people in this area. But right now she's able to go up and down the stairs. He has incipient asthma, and asthma is awful. I know it does. I've got a grandson, unfortunately. But right now it's not there. This is all directed for something that may happen in the future. And I have a real problem granting a variance now for something that may happen in the future. I don't think that the disability at this point is strong enough to grant a variance.
Not to be argumentative, but the question is whether according to the courts, whether the accommodation provides a direct amelioration of the disability's effect. So if you read that language, it doesn't seem to say it ameliorates the effect. It doesn't seem to say that the disability has to be so severe that they cannot use the steps at all. And if you're going to say that the disability has to be at a certain level before they're entitled to claim it, what would be the level? And would they wait until they can no longer use the steps at all to come in?
No, I don't think that's necessary. But right now you're talking about an osteoporosis that's being treated with a medication, very frankly, that I've been on for 4 years at this point, which may prevent any further progression of osteoporosis. We're talking about osteoporosis where there have been no fractures. We're talking about two people who do not have acknowledged handicaps when they drive. We're talking about anticipating something which may very well happen, and I hope it doesn't. I hope the medication works and she's fine. Difficulty going up and down the stairs. Man, I have to drag myself up and down the stairs with banisters, but it's possible. I just think we're too early with this. Because the problems that they have, I have a genetic predisposition to asthma and it may happen, or we have a diagnosis of osteoporosis that we're treating with medication and it may get worse. And those things may very well happen, at which point, if you need an elevator, you put in an elevator. But I think we're jumping the gun.
Can I make a
Henry?
comment? Are we
Yeah.
open discussion or?
guess
Jay,
so.
yeah, Jay, I'm gonna, in a moment, I'm gonna ask you if you have any questions, because I know you missed we did the questions first, so.
Okay.
So if you have questions, I'll have you talk about your questions. Let's see if Henry wants to follow up on Sherry's comment, and then we'll come to Jay.
Sure.
Two things. I may have missed it. Was there no ability to put in a stair lifter so that you would sit down and go up the stairs by some mechanism? Which is pretty common in two-story homes. I don't know, maybe the construction man can tell us. And the second thing is, I'm not so certain that
Yeah,
an elevator will ameliorate the osteoporosis, which I think is the definition that Bruce gave us. The variance that you're looking for doesn't ameliorate the disease or the function. But I'm sort of curious about the stairs.
I'm sorry, can you hear me now? I just unmuted.
Yes.
So right now there's a floating glass staircase in the middle of the whole structure that goes from the basement to the second floor. There's just no way to attach a lift system onto it.
Thank you.
Jay, did you have some questions that you'd like to ask?
Yeah, I guess I mean, I just wanted to make a comment or follow up on the discussion. So my thinking here is, I've read through the material. I mean, as a plan commission, what we really want to be evaluating is, are we setting ourselves up with this decision for a line of people to come through and say, well, because of this decision, my circumstances are similar, therefore I should be granted the same variance or relief. And I think, Bruce kind of discussed that a little bit. In terms of setting a precedent, we certainly don't want to set a precedent, but at the same time, I feel like the point of a plan commission, the reason it exists, is to discuss applications for a variance based on the specific set of facts related to it. If we were just rubber stamping no's on every variance request because it doesn't meet the ordinance, there really wouldn't be a point to even have a plan commission. It would just, asked and answered. So based on that and looking at the facts that are presented as part of this application, I do think it's worth a discussion to consider it, because we're not really responsible for evaluating the seriousness of the disability or how it impacts the lifestyle. More so, we are evaluating whether or not it meets our village criteria as far as the zoning language to grant the variance or not. And if we feel like the conditions of the disability do, I think it's worth a serious discussion, because what's being asked here is really, it's reasonable in terms of the request based on what's being asked for and, what our responsibility as a commission is to evaluate it. I don't know anything about osteoporosis in terms of the severity of the disability or how much worse it may get or how bad it is now. But I do think it does make sense to approach this idea of needing relief for the disability ahead of time, as opposed to when it becomes too late or when it becomes so impactful that the only reasonable option is to move out of the house or, in home care, whatever the next step is. I feel like the request is well presented, and I don't know. There is a strong argument that I see that the next person coming down the line looking for relief for a disability could not use this as a precedent. They would need to present their own new set of facts and circumstances in order to make a good case for a variance.
If I may I?
Certainly.
You see, there's a thing called preventive medicine. If all the malice disease, assumption is that without treating it, it will go worse. When one sees a opportunity or means to prevent that likelihood I think as a husband, as a father, as a mother or a wife, I think I should do whatever I can within reason, within my means. On top of that, osteoporosis seemingly pretty normal if you look at it. But however, once you hurt or break the bone, that part of the body is gone. You can't use it. I do not want to see that, and I do not want to regret that I could have done that to prevent it. In addition, asthmatic condition is, particularly emphysema, is irrevocable. Once you progress, you progress. Since, well, it is not, don't take it any other way, the endeavor that I'm requesting, by no means, it's not cheap. However, cost does not justify neglecting the means that I take it. That's why I'm doing what I'm doing. I do not want to wait things happen and then regret it. I will not. Before the likely event could happen, I'll move out. But in this case, I hope all commissioners weigh on the reasoning behind. That's what I can answer that. Thank you.
Thank you. Steve, did
Lori?
you have? Yes.
Yeah, Lori, I had something to ask. The variance, one of the things about we have the plan, we can use as variances is the impact on the other person. And he's made it clear already that he's spoken with Orphans of the Storm, and they seem to say it's not a hardship for them to have this done. So I think we could, use our rules and guidelines to protect the village or protect him or anything like that. But in this case, it doesn't seem like there's a negative impact on any party if Orphans of the Storm agrees with it. And, I'm not sure, like what were you saying? Not the guidelines, but the variance is pretty much cut and dry and it's factual. But when we get to a certain point, you have to make a decision. You have to look at the surrounding environment and see what impact those things have. And I just think that we could decide either way, but the fact that Orphans of the Storm doesn't have a negative impact or doesn't perceive a negative impact, that should influence us somewhat too, or can influence us some way too.
I agree with that. I think that's very important too, because part of our responsibility as a plan commission is not only to protect the statutes and ordinances that we have as a village, but it's also to speak for residents that are affected by projects, whether they're within ordinance or outside of ordinance. And I think it is important that we don't have a specific contest against this request by a neighboring property, at least not one that I'm aware of, which is it's an important part of what our responsibility is in making this decision.
Are there any other questions and comments? I would be interested to know if there is a less invasive type of elevator that can be installed. I am still troubled by a 10 by 10 addition into the side yard. Does anybody else have a similar thought, or Is that trivial?
No, it's not. It's very valid. I mean, the bottom line is, yes, we're here to guarantee or to protect, if we can, the adjacent homeowners, and in this case, Orphans does agree with it. But our other responsibility, as I see it, is to respect and protect our ordinances. And I have a problem. If we could cut it down, I might be comfortable with it. But this is a large inclusion into a side yard. And I don't love it.
Can I say something again?
Certainly.
I agree with you, except it's a large inclusion into a large side view. It's not like it's like perceptible. It's not like it's, it's crowding right at the edge or something like that. It's not causing any commotion. It's not interfering with traffic on the street or anything like that. And if we're talking about like, is it 10 feet, Lori, is that what you said?
10 by 10, yeah.
Okay, so if we went down to 8 by 8, you think any of us would perceive that from 40 feet away or from 30 feet away or something? I don't know. Frankly, if I had my druthers, the smaller the better. But frankly, I don't know what impact the size would have.
Well, it seems to me the problem is this, and it's beautiful. I've got to tell you, I look at the photograph of this and it's absolutely gorgeous, but no other form of elevator was considered. This was chosen because it was appropriate to the house as being a very modern house with a very modern elevator, but nobody looked to see if there was anything else that could go in. And the difference between 10 by 10 and 8 by 8 is 2 feet more inclusion into the side yard. That's what it is.
If I remember correctly, actual elevator is 6 by 6, and the elevator itself has to be protected by the hour inclusion, which is 10 by 10. And
no, we understand. We
do.
I think it's important to, sorry, I didn't mean to interrupt. Finish your thought.
Sorry, thank you. I was looking at some other even stand-up lift kind of a things, okay? But we were considering, in case we have to accommodate the wheelchair, that's where the conclusion comes in. Okay? And at the same time, to be honest with you, if we do it, why don't we do 2 kind of compatible to the existing structure instead of just putting something that so to speak, uncompatible, ugly. And actually, Orphans of the Stone, they I think we are attached to their approval or agreement. That's the only side that does not face or interfere any of the other residence buildings or structures. The other side is all wood, nothing there. West side is the next door house. So location-wise, so that's the only place that it could do it. The size-wise, that is one of the reasons that we consider it instead of a standalone. So 6 by 6.
Just to clarify, it encroaches on the setback by 8 feet, right? Because it says it goes down from 30 to 22.
Right.
That would cut into the side yard. I mean, it obviously doesn't take up the entire side yard. There's an 8-foot section that it cuts into, but only, 10 feet from front to back. And I guess really for our purposes in terms of evaluating the ordinance, it probably doesn't matter that much if it's, cutting in 8 feet versus 6 feet versus 4 feet. I think it's more, is it cutting in 8 feet or is it cutting in 29 out of the 30 feet? But again, I mean, these set of facts are so unique when you look at the, the photos, integrating the design into the house, oriented, and so it really visually is only kind of affected on one side by one neighbor. And then also on top of that, you have a very unique set of facts in terms of the staircase inside the house. I mean, I would guess that if this situation came up again, that the chances of any of these facts really applying to the next situation in terms of a floating staircase, in terms of, the side yard setback, it's very unlikely. So I think we can kind of look at this as a standalone decision as opposed to a precedent setting decision as far as the ordinance goes. That's my opinion. I mean,
Steve?
Yeah, okay, there we go. I'm not so much concerned about the precedents, again, because what we just said, everything is decided on a case-by-case basis. It's not like a blanket thing. And if this was going up and the next door neighbor was like closer, or the next door neighbor says, I don't want it, or I don't like it, or I don't want to look at it, or I don't want anything, that influences that particular decision. All things equal, it will still influence that particular decision. So I'm not so concerned about a blanket precedent being caused by this. I don't see that happening personally, based on what Bruce said.
I agree. I think Bruce pretty much killed the issue of precedent being a problem.
so then really, I think we're all seems like we're all kind of in agreement that the precedent is a non-factor. So then what are the biggest factors as a commission? I mean, you have the impact on the neighboring properties, and is that kind of it? Or is it, I know we touched a little bit about the severity of the disability, but I mean, certainly not my area of expertise. So is that kind of what we're looking at here, is what's the impact of the surrounding properties?
I think it's everything. I think it's, this particular situation with that particular kind of house, with its particular kind of construction, and the inability to do other things, like to make it internal. Many houses you'd be able to put an elevator inside the house. I mean, it's just, I think we need to make it clear that this is a very specific decision if we go forward.
If you make a vote and a recommendation of some sort, that this is, I should remind you, we would prepare a report, we would identify the basis for the recommendation. The report goes to the village board. So the ultimate decision rests with the village board, your advisory body, as you are in many other areas.
I agree, Lori, that we need to be specific, that this is based on specific characteristics of this house.
Right. Which I think is very appropriate. I think that's what we do. That's our job. Henry?
I'm curious.
I thought that it requires two facts to be found. One, that the house requires this elevator because of the specifics of the home. But I also thought it required that the change you were going to make is required to ameliorate the condition. Aren't there two parts to make this happen?
Henry, there are, I don't know what the federal courts say about what it means to ameliorate. I don't know if they look at it as you as a medical doctor look at it and say it eliminates the condition. When I read the federal language, it says a disability is impaired mobility. And as a layperson, it's hard for me to say that having an elevator doesn't increase mobility in a house with 40 steps. I know that's not a medical answer, but if you ask me as a lawyer, do I think that this affects mobility? I'd have to say I think this is addressing mobility. It may not be addressing osteoporosis, but I couldn't speak to that. But is it addressing mobility? I'd have a hard time imagining a trier of fact saying, no, this doesn't impact mobility.
Okay. I misunderstood it. I thought it had to ameliorate the condition. I thought that was the term you sent us in the memo.
Well, you know how lawyers write. We don't know medical conditions. We write flowery language, but.
Okay. I understand.
I mean, the key of the federal law is the reasonable and necessary accommodation, so that's what we're discussing, what's reasonable and what's necessary. Steve?
Yeah, just a quick, simple question. I'm assuming there are other elevators elsewhere in the village. Is that, I mean, at least it's potential for elevators to be elsewhere. Have we checked to make sure that this particular elevator meets the specs, that this the general construction specs that we have for elevators?
You know, those are governed by our applicable building codes, and they have to apply for a permit and meet all those things. We don't have to determine that the elevator is permittable, you know, feasible from a building code standpoint. They take that risk. And if what they propose isn't approvable, and they had to come back, for example, and say, oh, no, now the elevator has to be 11 feet, well, they'd have to come all the way back through this procedure again. We're approving what they propose. It's up to them to ensure it meets building codes and can be constructed.
Well, but there's been a lot of development of this plan. Has somebody checked that? Tom, can you weigh in on that?
I'm sorry, what was that?
Well, we're talking about, does the elevator meet the building codes in Riverwoods? I said, there's been a lot of development to this plan. Surely you've already checked that out. Is that right?
Yes, yes, as far as I know, I spoke to the architect and I also spoke to the elevator contractor. It does meet building code.
Any other questions or comments? Are we ready to make a decision, a recommendation to the board?
I think so.
All right, I guess we'll need a roll call.
Well, is there a motion to
Oh, we need a
recommend?
motion
need
and
a
a
motion.
second. And then,
Do we
sorry,
Thing or
have
another.
to, do we have to close or adjourn the public hearing?
We should.
yes. Hearing nothing further, we close the public hearing at this time.
Can I get a motion for that?
I'll move that we close the public hearing at this time.
Second,
Okay, Mr. Blaylock,
Aye.
Mr. Dat,
Sorry. Aye.
done. Ms. Greditor,
aye.
Mr. Levin,
Aye.
Chairman Brightcoff.
Aye.
Motion passes.
I also wanted to let you know that there was no other emails with other visitors wishing to address the board.
Thank you, Daphne.
Thank you, Daphne. All right, so are we ready for a vote?
Motion.
Okay,
We need a motion to, grant or deny the relief requested or with conditions.
all right. Do I hear a motion?
I'll make a motion to grant the variance as requested with conditions set forth by the Plan Commission. Do we need to outline the conditions in the motion?
Well, is your condition that it be based on the particular residence and that the relief granted, make it clear that it's for this particular structure in this particular house? I don't know what other condition you had in mind.
Yeah, I mean, that's kind of, I'm not an attorney, but the language that I would see as being relevant and necessary if we were to grant this variance would be that it's specific to this particular situation, this particular home. This does not grandfather in a future home if this home is demolished and a new home is built on this property. I don't know the right way to say that in terms of putting it into a motion, but that's
pretty good. And incidentally, the motion is to recommend the granting of the relief. This is a recommendation and it's advisory to the village board. So I understand what you're saying.
Can we also have a condition that the neighbor that is closest to the proposed structure has approved the concept?
Yeah, I think that makes sense to put it in.
Right.
And also, I mean, I know we talked about this, but do we want to make sure that the motion clarifies that this elevator has to meet all applicable building codes and standards, both for the National Building Code and the Village Code? Or is that kind of,
I think it's outside of our purview and not necessary.
okay?
And then
Right?
just to clarify, this is then going to the trustees.
Yes.
Okay,
We make a recommendation, they make the decision.
right, as usual. Yeah, okay.
As usual. All right, so Jerry, do you want to read us back the motion?
Sure. Mr. Dot moved to send a favorable recommendation to the mayor and board of trustees for relief from Article A, Chapter 11 of Title 9 of the zoning ordinance for the property commonly known as 2240 Riverwoods Road to reduce the required side yard from 30 feet to approximately 22 feet to allow construction of an addition for a new elevator to serve the existing residents with the condition that is based on this particular, that relief is for this particular structure and this particular house. A future home would not be grandfathered if this home were to be demolished. The closest neighbor, we want to ensure that the closest neighbor to the property has approved the concept.
Do we need to say the east side yard?
No, it's in the drawing.
We could say the neighbor most closely affected by the proposed addition or something like that.
Okay.
Has given its approval.
And Jerry, it's not relief from Article A of chapter, whatever, it's relief
Okay.
under those provisions.
Okay, thank you.
And I think it might be worthwhile to say the existing neighbor so that we don't look back in the future and there's someone else that's in that same property where the orphans of the storm is.
Okay, that's fine. Do we have a second for that motion?
I'll second.
Okay, Carl, I missed. Okay, Mr. Blaylock,
Aye.
Mr. Dot,
Aye.
Ms. Graditor,
Nay,
nay?
that's a nay.
Okay. Mr. Levin,
Aye.
Chairman Brightcoff,
Aye.
motion passes.
Okay, thank you, everybody, for that very interesting conversation. We did not have any visitors wishing to address the commission. I have no additional comments, so I will entertain, unless anybody has anything else. Is there any other topic? Steve?
I just have a general question, which I wrote to you about. Is there any news or, I mean, I get asked this and I'm sure we all do. Is there any news or update about any movement, real estate movement with Federal Live at 37 acres, the antique shop, et cetera, et cetera, et cetera?
That's probably a Henry question.
What can I tell you? I can tell you that apparently the Federal Life property is under some form of contract. We think it's for probably some form of residential units. We don't have anything specific yet on it at all, Steve. And that may or may not go through. The second one is the 37 acres. That's still under discussion. That would be more commercial in the type. My guess is that if that went through, that it would be voluntarily annexed as part of an overall agreement. There is nothing further on the, what was the name of it, where I used to get ice cream? What was it? What did you call it?
Cell barn?
I call
Yeah, the sale barn, yeah.
I call it the
Uh,
antique place. Just,
I
yeah.
had been in contact at one time with the niece, and we actually spoke with the attorney about a week ago. Apparently, there are some limitations on the capacity of the owner, and it has not gone very far because of that. But the answer to the question is there's nothing new on the sale barn. So the bottom line is there's nothing specific to tell you.
Okay.
Um,
Thank you.
That's probably a good summary. That's all I can probably add. Byung, I just also wanted to thank you for making your case tonight. And I don't know if you've seen the Plan Commission before. Everyone here is a volunteer and is doing their best to protect the village and some of the values that I know you seem to cherish so much in the village. So this is a novel case for us and one of the first ones we've handled under this regime. And I'm sure it'll be something that may come back to us again another time. But so this will go to, the recommendation will go to the village board. And I'll try and let you and Tom know at what meeting it will appear. It might make it for the meeting on June 15 for the village board to consider at that point.
If I may, I thank you very much, all of you commissioners, and at least the hearing and the considering our request. I hope it goes well and not disrupting or disappoint any of the village environment. At least we try to be healthy citizens of Riverwoods, if you guys can help me. Thank you very much.
Sure.
Thank you.
I have no comments.
Move we
So-
adjourn.
Second,
Mr. Blaylock,
Aye.
Mr. Dot,
Aye.
Ms. Graditor,
aye.
Mr. Levin,
Aye.
Chairman Brightcoff.
Aye. Thank you,
Okay.
everybody.
Thank you.
Good night.
Thanks.